let's begin up with our quick presentation slot, which is sponsored by IPNeeti. So we have a Shuchi Agarrwal. She's the founder and managing partner, IPNeeti. And the topic for the presentation is very much interesting, which I would like to highlight is a viewpoint on to WTO for exempting IP rights during COVID situation. So over to you, Suchi, for
Thank you so much, Mitali. A very good afternoon to the audience. I hope you're enjoying all the different panel discussions and the interesting sessions which have been put across for you. I would like to spend a few minutes chatting about, I think in today's time, the most hotly debated topic or the most discussed topic, which is about when is it that we are going to be vaccinated, or when is it that we see a drug that's going to be out in the market for treating COVID-19. Yes, recently in India, a drive, which is one of the largest in the world, has started for vaccination. But when I talk about the IP facet of it, there's still too much left to be debated for. So I thought in this particular times where this is the current hot issue, maybe I could spend a few minutes talking about really what is the point of contention and what is it that is being debated when it comes to COVID-19 related drugs, vaccines, diagnostic kits, etc. availability versus when I talk about, let's say, the IP rights associated with it. So essentially the background, as we all know, we are all looking for a panacea for this pandemic. Anyone and everyone across the globe has one voice. When is it that we're going to be treated, and when is it that we can fearlessly walk in the open, away from the lockdowns or from different measures being imposed for our own benefit, of course. But we all love freedom. So we are looking for panacea for this pandemic. The problem when I limit this particular topic is to IP is the protection versus public access versus research thing. So while this all happened very, very suddenly, there was not much time left, or there wasn't much time for research to come up with a drug. But given the kind of intensity the virus has offered, it was absolutely needed that a solution be devised, a drug be researched, so that it could very, very soon reach the market. Once a drug is available, it is being developed. The next question largely is that going to be protected? If yes, most likely the answer for the developers. When you talk about protection, then how is it going to impact, and how would that now yield for public access? Would it mean that if the company who has developed the drug is going to get a patent for the same, would that have any kind of limitations, or would that harm public access to the same? Given there could be a number of issues like costing, etc., which I'm going to deal later in the slides. And last but not the least, the problem of monopoly versus disclosure. So if a drug is going to be patented, of course, these are the monopolistic rights that people are going to apply for. Very specifically, the developers, the company, so they would want to have protection for a particular period of time, which is 20 years in the case of patents. And would that monopoly conceal, or would that monopoly lead to some sort of hampering in terms of disclosure besides what is required by or mandated by the patent law to get a patent? So with this particular background, to balance out the IP rights, the monopolistic character of the IP rights, and the public health or the public access problem, South Africa and India, they had approached WTO, which is World Trade Organization. The prime reason for approaching WTO was there was this particular proposal voted by the two nations saying that given this is such a deadly disease, the drug is still under research, why wouldn't there be an idea, or could there be a possibility for having such a drug to be easily available to all the poor countries to contain and prevent COVID-19 from being at abeyance from the IP rights associated to it. So essentially what they were advocating is that WTO to consider a proposal that for the drug to be easily available or to be available to poor countries without much restriction or limitation, the IP rights of this, there should be some checks being put in the IP rights. And what they could be, the suggestions were that until we're talking about a herd immunity kind of a setup or a herd immunity being achieved in the masses, the proposal was that there shouldn't be a patent being granted for any such drug that is being researched and developed during pandemic. And the fact that if at all there is a drug that is there which you found a new use or a new drug being developed, the enforcement of such a drug or maybe a vaccine or any other characteristic like a diagnostic kit, etc., they should be off patents or they should not be enforced while we are talking about people who have, while it is being administered to people in general, and specifically taking all of these perspectives from the account or from the perspective of poor countries who typically find it difficult and who might be struggling. In fact, there was a particular case, if I talk about, there was a drug during the times of Ebola, which was developed by Gillette, which was by the name Remdesivir. And while this particular drug was found effective to treat Ebola, the company Gillette that was producing the particular drug, etc., it was found that the stocks being produced were themselves, the amount or the quantity of drug produced was sufficient itself to just cater to a particular country or a few countries, and it could not reach to the poor countries. And given the fact that it was completely protected under the patent regime, it could not reach to the masses as much as it was required to serve the people. So the example cited was this, and the call to make here was to protect largely 70 poor countries. It could be a good option for now to suspend, so to say, the patent rights, and people could have better access to medicines. Now, the two sides, there were voices that were being heard which were in support for the measure, which was for access to public health. So they said, in order to ensure, and that lives are precious, so in order to ensure that people are being treated as opposed to people being generating money, it is important that this drug be kept off the patent regime, and therefore, at least for the time till pandemic is on, herd immunity is not being achieved. The two measures were being supported. Like it just dealt with, there was an anticipation that poor countries may be left out, and maybe just 1 in 10 people would be treated if the drug is not openly and if it is not available to masses without any particular IP restrictions. Also, what people relied upon was that this proposal also ties back with the Doha Declaration on TRIPS and public health, essentially in a layman term. So this Doha Declaration was arrived by a few countries put together, where they said that the TRIPS provision, which largely harmonized the intellectual property laws across the globe, via this declaration, it was stated that the countries, even though they have to harmonize their laws with the TRIPS-based guidelines, they are supposed to have a right to grant compulsory license. So there is a provision for each country that they could grant compulsory license to a drug or to a particular invention that they believe is required for their country on the basis of their situation. So in fact, even in India, we have had a couple of cases and one compulsory license being issued for a drug which was meant to treat cancer, as it was not sufficiently available in sufficient quantities to masses. The second ground under the Doha Declaration was there is a freedom for the countries to determine what should be the ground of license. So while TRIPS allows individual countries to have a provision for compulsory licensing, the grounds under which they could give a license is what the country needs to decide. It also allows countries to determine what would constitute a national emergency or what circumstances are there which could lead a country to come intervene a particular IP right and grant a compulsory license to other people who are willing to manufacture the patented product, etc. And the freedom to establish the regime of exhaustion of intellectual property rights. So largely these were the provisions being included via Doha Declaration to the principles or to the laws being laid down under the TRIPS agreement. Uh, there is this particular thing by Oxfam, nearly two-thirds or 61% of world's population, according to them, the estimate is that they would not have access to vaccine until 2021, which also was used, this particular research was also used as the reason why there was a support by the country saying that there shouldn't be a patent right granted or enforcement to drugs, vaccines, or any kind of diagnostic kits related for treatment of COVID-19. There were voices equally heard against the measure. The one being that there was no statistical or empirical evidence which was there that would prove that getting a patent granted for a vaccine, whether we talk about any of the other problems, I'm not going to say that there was something of this magnitude before, but for any of the diseases before, could prove that because there was an IP right granted to a particular drug that impacted the treatment or the access, public access part. So therefore, people said that there's no statistical evidence. Rather, it is all presumptive noise that is being made that if a patent is going to be granted to a drug or a vaccine, it is going to cause a lot of havoc to people in general. Second thing was largely, as we all understand, that every country is doing their best in order to expedite research and come up with a drug. The contention that given that this is largely a taxpayer money and this is something that is being used out of, let's say, exemptions or etc., this is public money which is being used for research. There could be, and the patent should be granted given the fact that there is going to be a public entity involved as well and a public angle associated to it. People also suggested that getting into this trend of not granting a patent for something as vital as a drug being researched and developed for COVID-19 could set a wrong precedent because this would deter people from researching further on to the new uses of the same drug, for example, in this case, mRNA vaccines, etc. And this might not be good for masses in general. And also, I think, which is one of the most important points being brought out here, that given TRIPS has given provisions of checks and balances, and the biggest check that I just talked about as compulsory license being available for independent countries to go ahead as and when they feel that the companies are misusing their IP rights, that should be invoked as opposed to a patent not being granted or enforcement being suspended. Of course, there is a counter noise to it that the entire procedure of getting a compulsory license is in itself long, tedious, and this is the need of the hour. People cannot wait for a few years for getting a compulsory license. This statement by a EU spokesperson saying that there is no evidence that IP rights in any way hamper access to COVID-19 medicines and technologies was being cited as one of the things. However, I think between the two extremes, there could always be a middle ground. And largely, I think what may work best in the current scenario is a middle ground where we are talking about, as opposed to having something which is a very hardcore enforcement, whether it is not granting a patent or just having no checks and balances at all. I think largely everyone and every company that is even coming out with a drug in this particular pandemic thing is also wanting to contribute to the betterment and public access or public health. So there are a lot of measures which are already there. There are a lot of companies which are there. For example, Moderna, they have said that they're not going to be enforcing their patents without absolutely any government tying this out. So this is a voluntary approach being taken by the company that they are going to make their drug available to masses in general and would also look out for partners to manufacture, not enforce their patents. Similarly, AstraZeneca has come back and said they are not going to be profiting from the drug. In fact, the pricing of their drug is $4 to $5, which basically, again, is something that is a welcoming step by the companies themselves. And it also reflects upon the moral approach and the ethical approach that the companies themselves are following without even having to put a negative limitation or a negative check in place for this. There could be another measure like a patent pool being developed, which could take care of putting things together. There could be other collaborative initiatives like COVAX being run by the UK government, where they've asked companies to pull in together and see how they could contribute to the public health and ensure that the drug is or vaccines are available to public at large. There could be even open COVID pledge, and companies like IBM, Amazon have come in support of these pledge, where the companies have voluntarily declared their support, be it in terms of research, whether in terms of funding or availability of drugs, by having out manufacturing partners being put together in making sure that the drug is easily available. So I would think that largely there is enough that we can rely upon. It is the time where we can trust, and we should trust the people who are not only researching, developing, but also as people who are our partners in ensuring that we would get the right the vaccines or drugs for our treatment. Um, a very, very negative check is not in order, as per what I would think about. Happy to answer any questions you may have.
Thank you, Shuchi. So we have one question in the chat box from Shifali. So you can see in the chat box.
So Shifali, the question I read out is, shouldn't compulsory licensing come in handy in this situation, as this is a win-win situation for R&D as well as LDCs, meaning to say, why was this proposal required? Good, a very, very good question, Shifali. So essentially, my logic as to why this proposal was being required is, if I talk about the entire process of a compulsory license being granted, it takes easily a couple of years. There are particular proceedings, there are particular procedural steps that you have to follow, from drafting a plaint to a rebuttal to both the sides being given an opportunity of being heard, etc., etc. And given the crucial stage at which we are, where till let's say last month, we did not have even a single vaccine or drug out for treatment, expecting countries or expecting people to wait another couple of years till the time a decision is being reached, whether the drug would be available or not at a low cost price or an affordable pricing, as to say, I think is what possibly one kicked on to this particular thing, that we should for time being move away from a measure that's going to prolong the access and not make it affordable versus getting this in place. I think that was possibly one of the rationale behind it.
All right, thank you. So I think, Shifali, your question has got the answer from Shuchi now. And do we have any more questions for Shuchi? So we can 2 minutes. And in the meanwhile, thank you, Shuchi, for joining for the wonderful presentation.